Good afternoon and evening, as the case may be, to one and all. In June 2016, the UK stunned the world when 52% voted to leave the European Union in a UK-wide referendum. On 29 March 2017, the then Prime Minister, Mrs. Theresa May, formally began the withdrawal process by invoking Article 50 of the Treaty of the European Union. The UK left the EU on 31st January 2020. However, there was a transition period which ended on 31st December 2020. A deal running to north of 400 pages on how the UK and the EU would live, work, and trade together was agreed on 24th December 2020. However, despite its length, no provision was made in the deal for the continued application of the recast Brussels regulation and the EU insolvency regulation. As a result, and Mark Phillips will talk about this when he sets stage, there's possibly no recognition in the EU of civil and commercial proceedings and insolvency proceedings commenced in the UK, at least for the moment, perhaps until when the Lugano Convention is acceded to. In short, it's a hard Brexit for the UK legal community. So what does this all mean for Asia? Should Asia be concerned? Is Brexit really a UK problem? And for Asia, is business as usual? What are the implications of the very recent decision of Justice Anthony Zaccarelli in Gate Group, where he held that UK courts will not scheme a debt unless it will be recognized in a foreign jurisdiction that matters? Despite Brexit, does the rule in Gibbs attract work to London? Does the rule pose a problem for Asian restructurings with English law denominated debt? Is the rule good to have? These are just some of the interesting questions that we shall grapple with today. With me to share the load and enlighten us with the answers are four eminent panelists who really need no introduction. However, it will be remiss of me not to say a few words about them. But before I do that, we are fortunate, very fortunate, to have with us Mr. Mark Phillips QC from South Square, a renowned barrister and one of the best advocates in the market, to set the stage for us. Glancing through Mark's very impressive resume, one thing jumped out. It's his outstanding body of work apart. He acts for the English Premier League, and he has acted against Manchester City. Mark, you've got all Manchester United fans on your side. Mark, over to you.
Judge, thank you very much indeed. Yeah, one of the problems about having prosecuted Manchester City on behalf of UEFA for breaches of the financial fair play rules, or alleged breaches, or breaches that were not established, unfortunately, is that I can't safely go to Manchester anymore. I might find myself on the wrong half, in the wrong half of the city, which wouldn't necessarily be a good thing. Yes, you started by taking us back to the vote in 2016, which followed the most extraordinary campaign, and the current fascination with fake news, I think, was absolutely set out during that campaign, and some of the outrageous things that were written, not least on the side of Boris's bus. And I'm not going to say how I voted. I think everybody can guess. But this is the third of 3 panel sessions on Brexit. And whilst I will not assume that everyone has attended the previous 2 sessions, I'm going to try not to repeat myself. Having said that, it is important that you have the context into which the discussion about how this impacts the Asian market fits. So as the judge has told us, in January 2020, the UK left the EU, but that made no real difference until the 31st of December 2020, when the transition period came to an end. You will, I suspect, have read the news about the successful conclusion of the negotiations and the fanfare with which Boris concluding his Brexit deal was met. But what we realised when we first saw the 1,244-page Brexit deal in December, just before the 31st of December deadline, is that in the insolvency and restructuring context, we didn't have a deal. The Brexit agreement did not do what many of us had expected. We did not have an agreement that in some way continued the EU insolvency regulation and the recast Brussels regulation on jurisdiction, nor did we have any sort of agreement along the lines of the European Union, the EU, giving effect to UK insolvencies under the UNTITLed model law, because as many of you may know, the UK has given effect to the UNTITLed model law through the cross-border insolvency regulations, and we will give effect to all EU insolvencies. But as far as we were concerned into the UK, we had a hard Brexit. Now, the most immediate question was, of course, the European-focused question, which is how are UK insolvencies and restructurings going to be recognised across the EU? And of course, is that a problem for the UK and the London market in particular? That's why on the 18th of February, the first panel considered the problem from a European perspective. The root of the problem in Europe is that UK insolvencies will no longer be given automatic recognition across the European Union, nor will UK court orders until such time as we accede to Lugano, and that doesn't appear to be happening at any great speed. The UK is now a third country. It's no longer a member state. In only 4 EU countries might UK insolvencies be recognised under the UNTITLed model law, because there are only 4 EU countries that have given effect to the UNTITLed model law, and those are Greece, Poland, Romania, and Slovenia. And you have to ask yourself the question whether the ability to have UK insolvencies recognised in Greece, Poland, Romania, and Slovenia under the model law in any way gives UK insolvencies and restructurings an advantage. So the EU insolvency regulation does not apply to the UK, but of course the EU insolvency regulation will be applied by the EU 27. And this is a point that's actually often overlooked, because that regulation is going to determine how member states deal with insolvencies falling within the regulation. And what I mean by that is, if under the EU insolvency regulation, an insolvency would be treated in a particular way, that is how it will be treated across the whole of the EU. So, for example, if the courts in Poland take the view that the COMI of a company that is incorporated in the UK happens to be in, say, Germany, that's binding on the EU, and there is nothing the UK can do about it. And it's only after you have considered the impact of the EU insolvency regulation on a UK insolvency, and I'm putting that very generically, that you can then turn to ask yourself, what are the domestic provisions that the various EU countries might then turn to? And that is not at all that is not at all straightforward. So you have to have in mind that the EU 27 will not recognise UK insolvency proceedings or determinations that are inconsistent with the determination of how a debtor's insolvency proceedings fall to be dealt with under the EU insolvency regulation. So that's the start. As against that, we of course in England have the rule in Gibbs, which means that London governed finance structures can only be reorganised in England or through an English recognised procedure. And there needs to be an English law insolvency or reconstruction but it is uncertain, of course, whether that would then be recognised across the EU. The discussion with the EU panel identified a number of problems resulting from Brexit, not least the point articulated by Mr. Justice Zaccaroli in his judgment in Gate Group recently, in which he made it clear that if a scheme or arrangement, as we now have to, will not be recognised somewhere that matters, that was the language that he used, somewhere that matters, the English court will not sanction it. And I am personally sure that the same approach will be taken by all of the English judges. The consensus in the European-centred panel seemed to be that absent a political solution, for example, an agreement between the UK and the EU, that the EU will recognise UK insolvencies applying the Unstrand model law, you would probably need an English law scheme or process to compromise the English law debt and an EU arrangement or process to secure recognition across the EU. The leading candidates for that appear to be, and I'm not being at all nationalistic on anyone's behalf, the new Dutch process and Irish schemes of arrangement. Now, I did just mention the possibility of perhaps having some bilateral arrangement between the UK and the EU. That is looking increasingly unlikely after the appointment of Lord Frost to take over from Michael Gove as the head of the English government on a Brexit, but we can hope. On the 24th of February, we had our second seminar that looked at the position from the North American perspective. And there was a general consensus that it put England into a different group in that it was no longer an easy springboard into the EU. And the view was that the UK was less attractive, but that this wasn't fatal, particularly when you had English law governed debt. The possibility was raised during that seminar of using US Chapter 15 as a springboard from the UK into the US and back into Europe. And properly analysed, that appears to be based on realpolitik, the realpolitik of assuming that companies will abide by US orders, regardless of the finer points of jurisdiction. Having analysed and thought about some of the finer points of jurisdiction, it is more questionable. Now, both panels emphasised one of the things that we are embodying this morning, and that is that cooperation between jurisdictions remains very important. There was a view that there are many able practitioners who practice in and around the London market, but certainty emerged as a key. And able as they are, the practitioners across the world really need to start to find an efficient framework through which we can conduct our restructurings and arrangements. So we now turn to Asia. And the question really is, or the core question is, how will the break in the easy access from the UK into the EU affect the Asian markets? Will it result in a drive towards London or away from London? Is it a problem for the UK? Is it a problem for Asia? Will Brexit weaken London's status as a powerhouse for financial services? Will the ruling Gibbs continue to make England a necessary destination for restructurings, or are there other solutions? Maybe it gives rise to opportunities for the Hong Kong and Singapore markets. And I, for one, am very keen to hear and understand what the view is on that. So we need to consider the impact of Brexit in Asia and what the solutions from your perspective, from the Asian perspective, might be. And with that, I hope not too long overview. Judge, I hand the floor back.
Thank you, Mark. Before we turn to the questions and the answers, let me introduce my panelists. First, Mann. Ian is Harneys Asia Managing Partner and a member of its litigation, insolvency, and restructuring group, Hong Kong. Ian is a recognized expert in insolvency and is ranked consistently in the highest tier in many of the leading industry publications. Next is Tiffany Wong. Tiffany is Managing Director of Alvarez and Marsal, and she has extensive experience and knowledge in corporate restructuring and dispute resolution with this particular focus in Hong Kong and the PRC. Her resume has many leading appointments in relation to PRC-centric restructurings. Third is Mr. Andrew Chan. Andrew is a specialist in dispute resolution, trust and insolvency with Allen and Gledhill. Is a partner there. Andrew has been consistently noted as a leading restructuring and insolvency lawyer in Legal 500 and Chambers, and he's also the general editor of a leading local Singapore practitioners book on corporate law and practice of corporate insolvency, and he's also co-authored 2 works on personal insolvency. Finally, we have Smitha Menon. Smitha is the deputy head of the firm's Wong Partnerships restructuring and insolvency practice, and is a partner in the International Arbitration and Special Situations Advisory practice. She also is the chair of the International Chamber of Commerce Singapore Arbitration Group, and recently Smitha was the first lawyer in Singapore to win the Woman of the Year in Restructuring Asia Award, conferred by the International Women's Insolvency and Restructuring Confederation. This is last year, I believe, Smitha. Congratulations. So those are my panelists, and with those introductions, let me turn to the first question. What does Brexit mean for Asia, or does it mean anything at all? At the EU webinar, and Mark noted this, the consensus was that this was essentially a UK-EU problem. There will be some impact on the UK, simply because the UK is no longer a stepping stone to the EU. At the North American webinar, the view was somewhat similar, and the US and the Netherlands were seen as potentially benefiting from Brexit. Is the Asian view the same? Maybe I'll ask Ian to kick off the conversation.
Sure, thank you very much, Judge. It's a difficult question because the answer must be very nuanced, and London provides us with, the world's highest quality silts, QCs, for example, that all of us in Asia, whether we're offshore, Cayman Islands, BVI like me, or practitioners in Hong Kong and Singapore and throughout the region, will use. Also, the practitioners in the law firms are second to none, and really are able to guide us and assist us depending on where they happen to be in the capital structure, as it were, in global cross-border restructurings, and their experience of not only EU law when it was relevant, as well as the model law on cross-border restructuring schemes of arrangement that we have inherited in other jurisdictions. All of that pedigree is really helpful, and I think will continue to be used where appropriate. And we have had some landmark cases, Asian cases, and when I say Asian, I mean, a classic example is Venetian, for example. I mean, that was a Vietnamese shipping endeavor that in about 2015 essentially restructured all of its debt through a scheme of arrangement in the London courts, simply because London had jurisdiction by virtue of the governing law of the debt being English law. Now, there was support from the Vietnamese government, by the way, and the creditors were very much in support. But it's an incredible thing that London should be used as a restructuring centre for essentially a Vietnamese endeavour. And then Inda Kiat was where I think a lot of us have worked on APP and Inda Kiat, and that there was a Supreme Court of Indonesia case as well as some New York litigation. But there was an attempt at restructuring before Mr. Justice Snowden in London. The Noble Group was an example where, you know, a group formerly listed on the Singapore Stock Exchange ended up being restructured it through a scheme of arrangement in London with some supportive proceedings in Bermuda for loosely what we call a pre-pack, and then, you know, more recently some cases like the Malaysian Airlines case. So they will continue, but they're not they're not necessarily all we do, and they are significant cases, but a lot of the cases we do are regional, and for me they tend to be BVI and Cayman plus Hong Kong. Sometimes it's you know, a little bit of Singapore and Hong Kong, and so that regional restructuring, I think, is really the mainstay of our work. And I think, just to sort of finish off the answer to the question, to ask whether it's Europe or Asia really must start with, where is your capital? Where does private money or public money, or a mix of the two, decide to deploy its capital? If all of your capital comes from China, then they are likely to want to use, you know, governing law clauses that are not English law. They might choose Hong Kong or Singapore. If your capital is coming from the region, they won't see London as the restructuring venue. They'll see it as Singapore or Hong Kong. So that's an important way of analysing the future as well, I think.
Thank you, Yuan. Andrew.
Yes. Okay, thanks, Judge. Now, the way I look at it is on the responses or impact on Asia, three possible responses. Number one, we simply ignore what has happened, because in a far majority of cases, what has happened in Europe has no implications. So first response, ignore. Second response, action. Already identified for Ian, and I will not repeat this, because the Gibbs rule, or if the assets there, we need to do something. So the second thing is action. Ignore action or take action. The third possibility is this: with every problem, we need to find solutions. The third response is to solve it. Now that Europe is split, it seems to us there are 4 countries, if you want to add England as well, 5 countries in the model law. So if we are going to perhaps, for example, solve on this topic of solve, find a jurisdiction which we can take a regime into Europe under the model law sort of this. Traditional schemes of arrangement may not satisfy the requirement of foreign proceedings. But you know, one of the beauties of Singapore's regime is this: we have scheme plus, because the additional provisions relating to insolvency are in the Insolvency, Restructuring and Dissolution Act. These provisions confer on the court's powers of some powers of supervision. They can control information and the like. The collective of what was historically, traditionally just the schemes, the scheme plus regime has a far better chance of actually going to Europe and having recognition in those 5 countries which have the model law. I surveyed some of the countries, the rest in Europe. The other countries, so are these other countries, some of them, for the purpose of recognition, requires COMI to be at a place for which the insolvency has actually started. Now, COMI is not just I shift COMI for particular purposes. The decision to shift a business must be driven by other factors as well: the business environment, the tax requirements, and what have you. Coincidentally, Singapore is ranked 2nd in the world for ease of doing business. Businesses have moved here. The point is essentially this: if you want to move to COMI, you move to Singapore. So the point is this: if you need to find a solution when you look at solve, Singapore has scheme plus, good chance under the model law. Singapore has good COMI, good place to do business. Another aspect into maybe for recognition. So my 3 points are this: ignore, take action, or solve. If I reverse the order, or put it in another order, solve, ignore, take action, that's SIA. So I think that Singapore Airlines, we can think of the responses in SIA. I'll leave it as that.
So would you solve or would you take action, Andrew? It's not clear to me what's your response.
Okay, the point is this: I mean, we could take action. You see, the action could be, I think, traditionally through the Europeans, but through the European system or whatever. I think there are difficulties. But I am postulating, when it comes to the point about solve, that perhaps we can look very, very much at Singapore, because 2 touchstones of recognition is the model law and COMI, and that's where I've given where Singapore has competitive advantages in terms of recognition Europe's and therefore possibly help solve. I'll leave it as that.
Right. So the short answer is that it's not really a problem for Asia, Brexit.
It is, but to the extent, I mean, okay, you're right, Your Honor. In the most number of cases, it is not. But in those cases which we are, I'm postulating that Singapore is one jurisdiction which could help solve.
I see. All right. Well, maybe we can just slide on to the next question, which is, will Asian companies continue to go to London to restructure? I mean, it's now a hard Brexit, we know, and so London, as Mark has pointed out, is a third country and is just another potential seat for restructuring, in much the same way as certain jurisdictions in the US, certain jurisdictions in Asia, and perhaps even Ireland and the Netherlands. With Gate Group, EU debt will not be schemed in London unless you've got some arrangement put in place. And we have seen in the past Vietnam Venetian going to London, that's 2013 pre-Brexit, and more recently Noble, which is also pre-Brexit, and post-Brexit, Malaysian Airlines restructuring in London. So will London continue to be attractive for Asian restructurings? Maybe I will ask Smitha for her views.
Thanks, Judge. I think for the reasons that Andrew and Ian mentioned at the start, London will always be relevant as long as the ruling Gibbs is there. And also the other main factor in my view is because of London's position as a financial center, but it's precisely for that reason that alternative restructuring hubs are now in play. So recently, it's quite common for global companies to borrow from financial centers that are in Asia. So Indonesian companies, Chinese companies, Indian companies, they tend to issue bonds or borrow from banks that are based in Asian cities like Singapore, Hong Kong, and Tokyo. So like London, when you have a large concentration of Asian creditors, you immediately start thinking of Asia as a restructuring hub. And there are benefits to having an Asian restructuring hub because of the presence of Asian financial creditors. I mean, just very briefly, first of all, influence. If you have a ringside seat, you can actually participate in the restructuring at an earlier stage and throughout the process. Quite often, if you're not part of the process and you try and advance your position after a plan is produced, you're just vilified as the person holding up or stymieing the restructuring. And in Singapore, for example, the system already builds in a lot of ability for creditors to wield influence if they choose to do so. For example, you can't extend your moratorium without showing evidence of support. Second, another benefit for Asian creditors with restructuring in Asia is a lot of Asian processes, and this is the same in Hong Kong, but I'll speak to Singapore. There's a lot of transparency, and with a lot of transparency, that builds in oversight and supervision to prevent abuse. So in Singapore, at least, creditors are entitled to financial information that they otherwise would not have access to. Information on the assets, the value of the assets, liabilities, key sources of revenue, disposals of assets, grant of security, financial reporting. So all of this gives them a better grasp of the situation. And I think that gives creditors, if creditors know that they are able to make more informed decisions at various stages of the process, including whether or not to sell their debt, that makes Asia very attractive for them to restructure, as opposed to sitting back and waiting till they're presented with a plan. And there's no context for them to decide during the process whether they should exit or how they should exit or how they should push for better positions in that restructuring plan. And the last point I'll make is better returns if you restructure out of a hub in Asia, if you're an Asian creditor, because new money tends to come from creditors themselves, if not the shareholders. And for Singapore, at least, there's rescue financing provisions that are built in. So that facilitates the new money coming from the existing banks, because our courts, as your Honor would know, has already endorsed roll-up financing, which makes it financially viable for banks to then want to lend to one of their existing debtors. And even if you aren't going to get the money from existing creditors, back to the first point, if Singapore or Asia, Hong Kong example, Tokyo, if you are a strong financial center, you already have an ecosystem for financing a restructuring. And one of the things that's a new development in the last 2 years is a lot of high net worth individuals and funds are looking at distressed businesses as a viable investment opportunity. since a lot of other investments have gone south, this is now the area to invest. And so if you have it in your ecosystem in Singapore or Tokyo or Hong Kong, then it's natural to have your restructuring there as well.
Yes, thank you. But obviously, you know, the fact that the debt is raised in Asia in and of itself may not be sufficient to keep it in Asia if you have the Gibbs and the debt is written under English law. And
That's right.
That'll be an issue we'll have to come to in the course of the discussion today
So
as to the Gibbs and
right, Judge.
liability. Yes, Tiffany, I was going to ask you the same question. Is London attractive for Asian restructurings? Certainly from the Hong Kong perspective.
Yes, thanks, Judge. I think London will remain as a top choice for like Asian companies to do their restructuring. But I think if the question is that whether like this is the opportunity, like following Brexit, whether like, you know, there is a good opportunity for an Asian city like Singapore and Hong Kong to be an alternative to London, I think one would like consider about, you know, if in order to be eligible or to be qualified as a hub for restructuring, I think one would consider if there is sufficient experience and quality like restructuring, insolvency, professionals and judges to make it work. I think like in preparation of like the panel discussion, I was like reflecting on like, you know, say if there is another noble group restructuring or something as complex in Asia, did that choose to be doing the restructuring in Asia, or whether they will still go to like London, right? And I would argue that London will not lose out as a result of Brexit, especially given that it has a new insolvency regime on the offer, and which offer like cross-class crackdown. And I understand the DIP, the DIF is in discussion, but I mean, let me like move it on, like, you know, to, but the question is that then why Asia would be an alternative to London? And I would say that like from the Hong Kong perspective, because like Smitha has already like spoken about Singapore, I think like say Hong Kong, I mean, it has the advantage of having, you know, one of the world's largest stock exchange in terms of its capitalization, and a very like a large creditor base than that of Singapore. And that also like a much larger number of experienced insolvency practitioners and lawyers practicing in the field. And just thinking about, and also I think something that is very significant nowadays is that just think about like, you know, all the major Chinese banks lending a huge amount into Hong Kong and elsewhere in the world through Hong Kong companies as the intermediary in the financing structure. I think it's all like important consideration as to whether or not, like, you know, to do your restructuring, let's say in Hong Kong or Singapore, or, you know, or in another jurisdiction. And as a practitioner, and I think I recognize that in Hong Kong, I recognize that we have our shortcomings in our insolvency regime. And unlike Singapore, we are limited by our lack of progression in reforming our laws. But I think fortunately enough, our judiciary has taken a much more robust role in cross-border restructuring, so that we have now a real force in Hong Kong, that like Hong Kong scheme can compromise that's governed by foreign laws. And I just give a few case example. In saying yes, that's governed by New York and English law were compromised. And in China, Lumina, the scheme which compromised bonds that were governed by mainland law was approved by the Hong Kong court. And yeah, and also as part of my preparation for this panel, I had a discussion with a barrister practicing in insolvency just yesterday, and he mentioned to me that in a case called Burville, the convening hearing for the scheme in Hong Kong, which seeks to deal with debts that were issued under Singapore law, was approved by the Hong Kong courts just earlier this week. So in none of these cases were gives an obstacle, and there was no need to get recognition in the US, UK, or Singapore for like in these cases. So I think this is like, you know, pretty significant development.
Well, does that signal that Hong Kong is abandoning the Gibbs? That'd be interesting to see. I see Mark smiling.
Yes. There's an interesting practical point, you know, about Gibbs, because of course there are occasions, I don't know what the Hong Kong law is as vis-a-vis abandoning Gibbs, as you put it, Judge, but there's an interesting practical point when it comes to Gibbs, because I think sometimes we as practitioners feel, overly fettered by it here in Asia, and certainly, it's perfectly possible to be, restructuring, say, a scheme, English debt. It won't be accepted by the English court, but it may be that your capital structure is such that all of your creditors consent to that. They enter an appearance in, let's call it the Hong Kong court, it could just as easily be the Cayman Islands court. Or it may be that the dissentient creditors that are in the money are all located in Asia anyway, and those sort of Gibbs holdouts are irrelevant and out of the money, and therefore their dissentient action, if taken in the High Court of London, wouldn't take them anywhere. It may be that you can gloss over the issue simply by getting yourself a Chapter 15, and I'd certainly been in cases between the Cayman Islands and the Hong Kong courts where we've had parallel schemes, multiple of these parallel schemes between the Hong Kong and Cayman Islands courts, where the Chapter 15 has essentially given its imprimatur of the two schemes in both jurisdictions, and then that ensures that those parties with a footprint in the United States are unlikely to disobey that order, whether or not the strict jurisprudential or juridical jurisdiction in the sense of power was there in the first place. So there's, to use Mark's expression, a bit of realpolitik, and equally, that there are occasions where recognition is not necessarily the be all and end all. You're looking for consent where necessary in the capital structure. You're looking for pragmatism and convenience. So I think sometimes we overestimate the chilling effects of Gibbs actually for us here in Asia.
Yes, I mean, that's a practical solution that you offered here, and I understand that the holdouts are not significant in the equation. It may be that Gibbs may not be a specter that one should be concerned about. I understand the point. But hearing everyone, it appears that there are options in Asia, and certainly Andrew and Smitha seem to think Singapore does offer a possibility, though London and Tiffany, Hong Kong as well, though London remains attractive for all the reasons that we all know and have described. But what do you see the Asian hubs or Asian options needing to do to be competitive vis-a-vis or in terms of attracting work into Asia, or keeping work within Asia? Maybe I'll start with Andrew.
I think much has been said about the advantages of what you need as far as Asia is concerned. You need the ability to bind, you need a good ecosystem, you need good jurisprudence, good tools, or what have you. If you ask me what is really needed is this: to build on our strengths and to build trust. Where I think Asia is lacking is the confidence or the perception. I mean, both the UK and the US have had a long history. So to me, I think the focus must really be, look, there are jurisdictions like Hong Kong, like Singapore, who got good tools. We need to engender more trust. We need to see enough big international matters coming in here and to show that they work. We're in the early stages. I think the history of the Singapore International Arbitration Center, we first started in 1991, 2 cases, unknown. In the late 1990s, early 2000s, I mean, look, this is reality. Some Singapore court decisions were criticized, but we've come a long way. So to me, everything has been said are the factors. We need to build a trust, we need to build the history, we need to build the perception, and we need to overcome this. So seminars like this will help.
Smitha, can I invite you to state your views? What more can we do? What should we be doing? Or what aren't we doing?
I think there are tools that can be made use of that are already there. I mean, I agree entirely with Andrew. I think the perception PR war is one that has to be constantly waged, because if you don't explain and show what you can do, you can't expect people to just come to you. So I think more work has to be done by Asians on that score, and being able to articulate how and why we can do it, and why there'll be certainty in the process. I mean, the existing tools are the same everywhere. I mean, there's the model law, there's common law as an avenue for recognition. There's the principle of reciprocity, which I think is where the UK will have difficulty because of the Gibbs rule. But certainly in Asia, that is proving a way for us to offer something that Europe can't, which is the ability to enforce your judgments in China, and hopefully over time, Indonesia and India. I think that would be the game changer for Asia. If you can find a region whose compromises are upheld in Indonesia, China, or India, then I think that's something that Europe has not been able to achieve. I mean, speaking very frankly, apart from relying on Chapter 11 and the fact that banks are in the US. So in Singapore, for example, the Chinese courts have recognized several judgments from the Singapore courts, and there's a memorandum, as the Honour will be well aware, there's now a memorandum of guidance on recognition and enforcement of money judgments, and that has actually been applied in a recent case in 2019. So I think if we do more work focusing on how within Asia we can offer this solution through reciprocity, because that is really what ASEAN is built based on. That's something that is a bit different that we can do, which hasn't been done before. And last of all, the same, taking a leaf out of the European playbook or the English playbook, which is constantly ramping up Asian cities as financial centers, because that's really what gave the Chapter 11 process its legs, because you can have enforcement without actually needing to enforce, in the sense that if your banks and your funds, all your corporate vehicles through which fundraising takes place are in Singapore or Hong Kong, then you don't even need to worry about getting recognition overseas to prevent enforcement. These banks would not want to act against a Hong Kong or a Singapore judgment in any event. So you get soft enforcement that way. And I really think that's another area that we can build up on.
Well, of course, that brings us to the question of the Gibbs. And of course, London being a big, large international financial center, the fact that it may not recognize a restructuring, albeit in relation to debt raised in Asia, is of a matter of concern to creditors and to debtors, and therefore affects the issue of, or relates to the issue of certainty. So coming to the Gibbs, we know that a fair amount of debt that is raised in Asia is denominated in English law, even though the borrower is not committed in the UK, it may be committed in parts of Asia. And we also know under the Gibbs, the UK will not recognize any restructuring, either in the common law or under moral law, of English law denominated debt, even by the Comey Court, if it's not done according to the choice of law. If it's English law, obviously that's the UK. And then we, of course, have Justice Zachari's point in Gate Group, which reinforces this very same point. So the question really is the rule in Gibbs, or does the rule in Gibbs have the effect of making London relevant to Asia? And the answer to the question is, does it really help London? May I start with Ian and Andrew and Tiffany in that order?
Yes, I mean, I think London will continue to have that Gibbs anchor, and it's very settled law. The Court of Appeal case in the Bank of Azerbaijan and Sberbank, and permission was refused to go to the Supreme Court. So, and without legislative change, I can't imagine Mark will know better than me, that will happen very quickly. I think Gibbs will be around a long time, and that will pivot the decades of English law debt raised here in Asia, and we will find ourselves using the English courts. And as long as that's not that doesn't have to also be recognized in Europe, I think we'll be very happy with the service that London provides. But what will be interesting is, the China-EU trade deal that was signed just after Christmas is a monster new deal. And in 2019, trade between the EU and China was 198 billion euros per year. That can only get a lot larger because of the freedoms under the deal. And it will be for all of us to consider carefully what the governing law ought to be. Is it, when you're talking about trade between two countries, the countries, the partners will negotiate as to what the governing law is and where the resolution ought to take place. And that is not just for the China-EU deal, but it's also for the Belt and Road infrastructure projects. But when you're investing in a country as opposed to a mere trade deal, it can very often be the investee country's laws that apply. So if China starts investing heavily in the old Eastern Bloc, Eastern Europe, for example, then London will be a less viable option to restructure those types of arrangements. The old days of Europeans using London for restructuring, shifting Comey and restructuring there will become less relevant. So we need to think carefully about how we position, the proper law at the beginning and how the trade and coming back to finance affects things. I would just, going back to Gibbs there, the US and Singapore are the two super countries that are these amazing non-Gibbs jurisdictions. And there's an incredible benefit, but also an incredible danger there, because any court that wrongly takes jurisdiction in the eyes of creditors will then be criticized. So, they shouldn't have taken jurisdiction. It was English law, and it was a Taiwanese company. Why did X court take jurisdiction? So I think those matters have to be dealt with in a very mature and generous way, and that goes to us, the practitioners, as well. We have to be careful in any restructuring that, if there is a Cayman Islands entity, then of course the governing law is Cayman Islands, and don't forget the place of domicile, to use the old language. If there's a Singapore company with Singapore governing law, look to Singapore, find the most natural place without arbitraging off each other and fighting within the community of the talented practitioners we have here. So I think that level of restraint will be important for all of us in Asia to get the right post-Gibbs balance, with Singapore obviously leading the way.
Yes, Andrew, choice of law seems to be very important. Choose your choice, choose your law carefully.
Yes. So I'm going to assume, for the purpose of my answer, that England is not going to change their position on Gibbs for a decade or for some time more.
Well,
let me postulate.
It's clear.
Let me postulate 4 solutions. Solution number 1. The point about being binding or affecting creditors, so what the other mechanisms, if you structure such in a particular way that there's a high incentive, you get them to participate, file a proof of that, you pay them 30% at the beginning, and then maybe later. These people can take their chance and ignore, or they can participate and take the benefits. Once they take the benefits, it's difficult for them to blow hot and cold. They submit to the jurisdiction. So other mechanisms to overcome with my first point. Second point is this. In the decision of Shivia, basically the issue which actually arose, this was, I think, Azerbaijan sort of restructuring. They went to England under the model law, essentially seeking the proposition that they wanted a permanent stay. The court said they cannot grant a permanent stay, not appropriate in the case. They also took the view that it cannot continue it can only continue for so long as, if you like, the foreign insolvency proceedings actually continue. So there's a limitation in terms of stopping people from suing, relying on the model law. Azerbaijan changed their law. Singapore already has the possibility post-scheme of actually continuing with court supervision. Section 72 of our Act enables the court to continue to enforce or give effect to the particular scheme. It also enables the court to clarify. In one sense, the end of the sanction or the lodgement of the court order is not really the end. Maybe we extend our laws a bit more, in which case we may be able to overcome, if you like, the Gibbs rule, not so much because we're compromising the debts, but rely on the model law because the foreign proceedings are still on foot and barring the action. So think about this. We have already some potential language to 72. In other words, the beauty of the scheme class is we have features which helps us fit and gives us possibilities for better and more extended recognition. The third point is this: pull the rug under this particular company or this particular play. The point is this: I can transfer the assets into another company, or I can re-domicile that company to Singapore. Sure, you sue that company, that may not be compromised or what have you, but I re-domicile the assets here. And there is a principle of common law, which is this: and then I dissolve, I wind up the company in the country. It depends on the law of the particular country whether they continue to exist. And that law has wound up the company. The assets have been the company has been re-domiciled here. Assets has been moved here. So to the Gibbs rule, the other principles which might counteract that. The fourth point is this, and this is a fourth solution. The Gibbs rule essentially says we cannot compromise the debt. Fine. Why don't we do this? For related debt, because both English law, Australian law, Singapore law, for schemes, they say I can have a third-party release. One particular theory of that is that it bars. So let's say you have a principal debtor as a scheme, and then you have a guarantor. It basically bars the action against the guarantor because it's circuitous. The guarantor can come back and make claim. What then the scheme does is it bars the company and between the company and the creditor, and it bars the creditor from proceeding against the guarantor. Using the same particular technique, you do a Singapore scheme, or you do, let's say you set up a company which assumes a particular debt. It's the same particular debt, and then you bar, and this is a Singapore assumption or a Singapore debt, then you bar the taking the action against the company or the debtor under the English law governed like instrument or whatever. In that particular sense, we are not seeking to outflank the Gibbs rule. We are essentially seeking what is a Singapore scheme, essentially asking the courts to say, look, I did not start with English law. I started with Singapore scheme, Singapore perspective, and this is third-party release. You, England, are doing the same. If you want to be an international center, you would say, I can bar the English law debts, I can scheme this. I can also scheme or bar the actions of local security which might be governed by Singapore, Hong Kong, or Chinese law. What they seek to do, if they try to take that particular principle and say, no, only English law, then they cannot be consistent for the related obligations. The moment we accept that the gateway is then the third-party release, it seems to me that there is another angle for which we can counteract the Gibbs rule. Four possibilities to be developed perhaps in the future.
Well, Tiffany, I'm going to take this to you, and then there's a question from the panelists which I'll pose after Tiffany's response. So all of this, the entire discussion is because we want to accommodate the Gibbs. Should we accommodate the Gibbs? Is it something that we should move away from? And for reasons which have been cited in various judgments. I think Riz Mukul was quite critical of the Gibbs in the EU session. And in the North American session, I think Alistair Beveridge of Alex London described it also in, he described it as an anachronism and inconsistent with London's willingness to restructure debt subject to foreign laws. So should we just forget about the Gibbs so that we can we don't have these problems to deal with? And the question I would like to take to the panelists is from the floor is would the adoption of the model law on cross-border on insolvency judgments be the solution to the Gibbs? And I suppose this is a question maybe Mark would know. Is it likely to be adopted in the UK and other major centres? I can't speak for Singapore at this stage, but we will. That's a question on the floor. But maybe Tiffany first. Should we just move away from the Gibbs?
Yeah, but I mean, before we move away from the Gibbs, I think Ian and Andrew have already given a very good legal analysis about Gibbs. But I think as a practitioners, a non-lawyer, I think more often my job is to ascertaining the wishes and the views of the creditors. I just see that, say in Hong Kong, under Hong Kong law, I mean the law that I'm most familiar with, the court has managed to work out a few ways, to overcome Gibbs in cases. I think one of the key consideration is that, as I said, the wishes of the creditors, and in the case of a case called Sing Yes, which I mentioned earlier, basically 100%, I mean, based on my research, 100% of the holders of the convertible bonds had acceded to the restructuring support agreement, to the RSA. And ultimately, and the scheme under Hong Kong law was approved by the court, because it was held that the creditors had submitted to the Hong Kong law under the scheme, and yeah, it's just there are sufficient credit support for the scheme to go through in both Sing Years and the other case is China Lumina. So so that's why I emphasize that legal, of course, the legal analysis, the very long established Gibbs law is very important, but also the creditors' wishes is always, I think, key to the success of the restructuring.
Thanks. But yeah. Mark, sorry, Ian, if I just may ask you this, why shouldn't the Comey Court restructure a debt simply because pre-insolvency parties have written another choice of law? Or with it, should we not just go with the Comey concept and give less importance to party autonomy?
Well, Comey obviously changes, and Comey is an UNTITLed model law and cross-border insolvency concept, and so it doesn't apply in those jurisdictions that haven't enacted it, and for the parallel schemes that I do regularly between Hong Kong, Cayman, BVI, Bermuda, Comey isn't a juridical concept. It simply doesn't exist. Comey, obviously is very important, and it's a very sensible measure of, what jurisdiction ought to have some power to restructure. But the pre-Comey step, a lot of people would say was the proper law, which is the Gibbs step. But I think Comey is obviously massively important and will continue to be so. The obvious fix for us, and Tiffany quite cleverly mentioned Sing Ye's and China Lumina cases that I've been lucky enough to be familiar with, and the fix often is simply having a parallel scheme of arrangement. So if you think there is an issue with Gibbs, then do a scheme of arrangement in London in addition to your Singapore process. And I would really encourage people not to be scared of opening up a multiplicity of proceedings. That, for some jurisdictions, the old Gibbs jurisdictions, if I may say, we're very used to opening up parallel proceedings, and it's a tiny fraction of the cost in terms of the savings, the rescue, the other advisors' fees, the success fees, and all the rest of it. It is merely a court proceeding with a scheme of arrangement that's conditional and interdependent. So you have a duplication of the work that, through good practitioners, that they can ensure that duplication is used effectively, is what I'm saying. So a lot of the work done in Hong Kong can be also used in the BVI scheme or in the London scheme or wherever. And then, of course, there's the issue of assets. If you don't have, if the obligor, the debtor, doesn't have any assets in a Gibbs country, then you may as well ignore that country, actually. That's another feature. But so I'm not disagreeing with you, Judge. Comey is increasingly important. And if the rest of Europe were to adopt the UNTITLed model law, they could cooperate better with England, no doubt. And Comey would be really important.
Yes, well, except that the place of incorporation is presumed to be the Comey. So in a sense, it dovetails with the common law concept of jurisdiction. But anyway, sorry. So parallel schemes seem to be the prudent thing to do, and I think that's how the market has dealt with the Gibbs. But Smitha, may I ask, pose to you the question from the floor? If we adopted the new UNTITLed model law and the solvency judgments, it's not new; it's about 2 years old now. Would that be a solution to the Gibbs issue? And your views, please.
I don't think it will. I can't see an English court exercising its discretion, knowing that this is a way to undermine the Gibbs rule if the Gibbs rule is meant to be upheld, essentially. I mean, they'll find a way. The UNTITLed model law, I mean, that's a downside with treaties, right? To make sure that you get high level participation, you have to have loose language. And I think there's enough room for a court that if the English position wants to uphold Gibbs, then the model law won't help. On the face of it, it does. It gives you an avenue to try and make the arguments, so you can, with some integrity, make arguments. But I think if it's a policy decision at the end of the day. If the position is that Gibbs is there to stay, then it won't help. I'll just give you a way to try.
Right.
Sorry, just Josh, if you don't mind, I'll just add another perspective. So I think that if the new model law implemented, the problem or difficulty is whether there's any political will in the UK to actually do that. But it seems to me that the English position, and I'm happy to be corrected by Mark, is that so far they've regarded, if you like, the systems to be very much procedural. The effect of the new model law, in effect, requires the recognition of giving effect to insolvency-related judgments or what have you. If that is the case, it seems to me, if enacted in the same particular manner as recommended by the new model law, then that is a solution to Gibbs. But again, I stand corrected on my understanding as to English law.
Yes, well, I think that there'll be something for consideration by due course before some forum. Yes, so let's move on from the Gibbs and let's talk about issue of recognition. I think Smitha talked about recognition within Asia, and is recognition really, if we have an Asian hub, Asian restructuring option to London, for example, is recognition really a problem? I mean, London has the same issues, I mean, so far as Asian restructuring is concerned. So within Asia, we know that very few jurisdictions have adopted the model law, and not all jurisdictions are common law based, and therefore common law recognition may not be readily available. So how do we deal with the issue of recognition within Asia? Tiffany first.
All right, thanks, Judge. Yeah, it's to me, it's always a difficult question in terms of like recognition, because like from the Hong Kong perspective, yeah, we all know that Hong Kong has not signed up to the model law. But I mean, but I think there's some like and we rely on the common law principle of insolvency assistance. I mean, I think it will remain as the key principle going forward. And I think for the model law, it's only my thinking is that it's only until the date from which the PLC has signed up as a member state that like Hong Kong, if we ever going to like claim ourselves to be a nation like a restructuring hub, that we will have a chance to have the model law enacted in Hong Kong. But I think one interesting observation or thing that I would like to report here is that I think reciprocity is like a key consideration, I think, for creditors and debtor to consider. And I just like to report that there has been like some recent cases of which the bankruptcy administrators appointed by the courts in mainland China were recognized by the Hong Kong court. And I would say it is expected that the mainland court will reciprocate, and then we will see. But I mean, there has been quite a lot of informal and formal discussions between the judiciaries in Hong Kong and the mainland China in this aspect. And I think if one day, and if it's become formalized, I think it will be a game changer for Asia.
Thank you. I'm going to move on, given that time is ebbing away. I'm going to talk about forum selection. If there are suitable Asian hubs, assuming that's the thesis, so that's the conclusion, we have to think very carefully about forum selection and commissions. The excellent judgment of Justice Zaccaroli in Gate Group is very interesting. In fact, the structure used in Gate Group is very interesting. Gate Group, as we all, for those who read the judgment, will know, was a Part 26A plan application and concerned also the bankruptcy exception in the Lugano Convention, and involved a co-me shift and a co-obligor structure. And the plan company was incorporated in the UK for the purpose of co-me shift, and it executed a letter of indemnity and contribution under which it agreed as primary obligor to indemnify the debtor companies in the group, of which two of the debtor companies, one was the parent, and that company was incorporated in Switzerland. And some of the debt was English law denominated and others were Swiss law denominated. Justice Zaccaroli made some remarks about the structure being artificial, but he nonetheless convened the scheme meeting. Smitha, would this structure work in Asia if you were to shift code?
Yes. Yes, it would. I actually think that we can even be more bullish and not shift Comey for it to work. I know in Gate Group, this was a consideration. I think that is important. If you can shift Comey, that would be ideal. But there are situations where you may not be able to, or doing so would be so artificial, it would be pointless. The structure would work, especially because there's nothing typically that would restrict a company, an SPV, voluntarily undertaking debt. Where you would probably create some friction is you are telling the creditor that, oh, look, there's one more company that's going to owe you money, which is all fine until you then go tell the creditor, I'm going to take that one more company and use that to compromise the debt. And in Singapore, it would definitely work because we recognize third-party releases. And I think Andrew explained this concept earlier, and where you can release the guarantor when you restructure the debt. And what we're doing is the tail wagging the dog, where you restructure the guaranteed debt and release the primary debt. So the structure definitely works. Since the CODER scheme, a lot of practitioners have been looking at the structure with a lot of interest as a way to not so much get around things like Gibbs and so on, but as a way to put all the debt in one place. I think that's the main benefit of that structure. We've tried to use the structure, it hasn't come before the courts yet, but we tried to use the structure in situations where the debt is scattered. It's different kinds of debt, different laws, different jurisdictions, different places, and you're going to have very messy, expensive restructuring if you can't put it all under one SPV or in one central proceeding. And that's where I feel this co-obligor structure comes through very strongly. You don't really see in Gate Group because there wasn't that much debt. It was just bonds and finance and bank loans. But we've seen in others where there's mezzanine debt, there's secured debt, there's bond debt, there's semi-debt in the form of perpetuals. That's where I think this structure would be great. It would be fast, it would be simple, it would be very clear, and everyone's interests are dealt with in one forum, as opposed to you having to apply your mind across a range of places. So yes, I'm in favor of the co-obligor plan, and we're trying very hard to make it work.
Right, and I'll reserve to consider your arguments. Ian, your views.
Yeah, I mean, Gate Group was interesting because I think it all gave us great ideas about how we could be using new structures to try and have some holistic sort of approach to. I think initially when you read that it's the incorporation of the new company itself that's creating the Comey shift, but actually it wasn't that. It was the new structure was just needed because the quorum on the bond indenture just meant that you just couldn't get the right majority. So that was the point of it, and therefore it doesn't quite sound so bad, if I may say it, so bad in the sense of forum shopping. And then in fact they had already successfully shifted Comey just to prove that the English court wasn't just getting jurisdiction by the incorporation of this new company. So I think they did it remarkably with great grace and finesse, actually, if I may say, in this particular case. And again, something we'll all have to watch out for in the future if we try to be this creative. But I thought it was interesting that the judge, just wanted to point out, Mr. Justice Zachary wanted to point out that if you're going to do these things, then clearly it's not going to be acceptable whether you get away with the Comey shift, you do it rightly or properly or not. It won't be acceptable if the result is that you unfairly override legitimate interests of creditors pursuant to the contracts governing their relationship with the primary obligor. And he's very firm on that. If the effect of all of these artificial constructs, as he puts it, is essentially wrong, treating creditors badly and unfairly, then it won't be sanctioned. And he goes on to say it would also be sanctioned if my scheme won't be recognised anywhere that matters, as Mark says. So it was a very interesting case. I can't wait for one of us to try using some kind of SPV structure in this way for the right reasons.
There's a question that's been raised. Sorry, Judge, there's a question that's been raised that touches on this directly. The question is, what would be the effect of a creditor purporting to disclaim that deed of contribution? And that's precisely what Ian just mentioned. And I think this is where the practitioners have hit a wall, because we are asked to take a position on how would the court view this if a creditor turned up and said, I'm sorry, I don't want this person to be an obligor for my debt. It's just a roundabout way to shut me out from the process. And since the creditor's views are quite important, and I think we'll see that in the videology case as well, the creditor support is very key. I think that's where we are waiting to see some court pronounce a judgment on how that would work out. I don't know if Andrew and Ian would agree, but if the creditors say no, I think it's a bit difficult.
It comes back to, well, sometimes creditors quite perfectly entitled to just be holed out and be difficult to get a better result. But also it may be, what is the alternative? In this case, in the Gate Group case, the alternative was a Swiss court, and so that no doubt was a factor in the calculus. And it will depend what the alternative for you guys might be in Singapore, whether it's Indonesia or wherever, and the confidence that you would give as a jurisdiction to the process. Therefore, you know.
I'll be very brief. The moment you accept the proposition that you can have, if you like, companies or SPV sets up, and that already forms the court's jurisdiction, it must be, therefore, the court has jurisdiction. Then the question moves on to the question of discretion. The disclaimer, I think, should be a factor which is discretionary, because, I mean, you either have jurisdiction or no jurisdiction. Once you accept that that is doable, and there's a number of cases which says you can do that, therefore, because schemes are mandatory, I think we have passed the jurisdictional point. I view disclaimers as a matter going to discretion rather than jurisdiction.
I mean, you know, we've all thought of sort of funky arrangements. I've often thought, well, you know, BVI law sometimes has better legislation than Cayman Islands law, and sometimes the other way around. Like, you know, there are provisions within both companies' legislation to migrate or continue into a new jurisdiction. And if you could do that without creating defaults and, you know, transform the company from one jurisdiction corporately to another, could you then take advantage? Well, you must therefore be able to take advantage of the different regime. I've never done it, but it's something I've always thought would be interesting, you know, to look into, so long as you didn't create defaults that cause acceleration by doing so. You know, so it's worth the creativity that comes from conversations like this is why insolvency practitioners and judges all need to talk to each other.
Well, I think we will have to now pass the baton back to Mark to sum up. We have one more topic, but I think time will not permit. I wanted to talk about videology and Justice Rowland's excellent judgment in videology. I think it's a very important judgment. But the sense I get is that London will remain relevant for all the reasons we all know and acknowledge. But there are options in Asia one can consider, and we will all have to work on the basis that the world has changed somewhat because of Brexit. Mark, over to you.
Coach, thank you very much. I think I now have 2 minutes in order to summarize that incredible debate. I'm going to do it around Andrew's 3 questions, if I may. The first he raised was the possibility of ignoring it, and I'd simply say that that is unlikely, and it's been fascinating to see the number of different points that it gives rise to. The second question really brings us back to Gibbs and also the location of capital. And it's quite interesting, because listening to the Asian panel, the bigger issue seemed to be Gibbs than Brexit. And I'm just going to throw 2 little points out. The first point is that I have long thought that it is possible to persuade the higher courts in England that Gibbs is no longer applicable. And I'm just going to tell you why. It's perfectly valid reasoning in the 19th century, and you had an English contract and a French bankruptcy, and unsurprisingly, not least because of the relationships between the 2 countries, the English courts took the view that a French bankruptcy could not deal with an English debt. But I want to postulate this, because in those days, an English parties entering into an English law contract would not necessarily assume or contemplate that there would have been an event in a foreign jurisdiction that could discharge their debt. Transport that to the modern day, and I would argue that even if you have English choice of law, why don't the parties contemplate that in a modern environment, a restructuring in the COMI, for example, would be a valid way of restructuring that debt? And if that isn't an answer, I've never understood why we don't put into these English law contracts a provision that says that the contract is subject to English law, but may be restructured in accordance with, say, the law of the COMI. I just throw that out there because Gibbs seems to be this enormous 19th century problem. The other point that was made was the capital location, which is often London-centric. I love the comments that we will always be relevant. I feel deeply loved as a result. I think that Tiffany said we remain a top choice. It was interesting also to listen to Smitha explaining how increasingly creditors are taking Asia-centric instruments. I heard the ringing endorsements of the practitioners and judges in England, and I think the polite thing for me to do is just to make no comment on that at this point, other than to say that this demonstrates that one of the wonderful things about our area of practice is actually there are some really good practitioners right across the globe. So that was the second option. The third option was Solve, which I won't suggest that that was just a pitch, but Andrew very persuasively suggested that Singapore could be a jurisdiction from which we could use UNCITRAL for recognition. I heard the same from Tiffany. Obviously, you're contemplating using restructurings in those jurisdictions, and it seemed that it gave rise to three possibilities. I hope I haven't got this wrong. One was move the COMI and move it to Singapore. The second was change the choice of law, and that goes back to the Gibb point that we were just discussing. And the third is to actually use the synthetic structures that we were discussing at the end to create an Asian-based structure. One final point, incidentally, Andrew is absolutely right in relation to whether the current UNCITRAL law was going to be a solution to Gibbs. And I'm sorry, I should have mentioned this when I mentioned Gibbs. We've got the Rubin problem. We've got the Lord Collins judgment problem, where he said it is all procedural and Gibbs is substantive. But what I would say against that is that Lord Collins has gone. His particular interest in Dicey and Morris is no longer sitting against us in the Supreme Court, and that might be quite interesting. As I said, I do think there are arguments that in a modern environment, maybe Gibbs isn't such a hard and fast rule as everybody thinks. As far as the political side goes, I don't detect either the time or the inclination, certainly in the British government, to do anything about it. One possibility that has been discussed is whether, in exchange for a bilateral agreement with the EU, that the EU will apply the UNCITRAL model law to English restructurings, English law restructurings, that the UK may have to soften Gibbs. It's not been suggested abolish Gibbs, but I have heard it suggested that perhaps we should soften Gibbs. Who knows? Thank you very much. I see I have gone over the time, for which apologies, Judge.
Oh, thank you, Mark. That was excellent summing up, and I really very much enjoyed your arguments on why the Gibbs should not be followed anymore.
Can I appear in the Singapore court? I'm not sure that I can appear. I'd love
well, you need leave. You need leave, but
all I need is one of you to instruct me, and I'm up for it.
I think that's directed at Andrew and Smitha. Anyhow, it leaves me to thank everyone for making the time and for contributing to what was a wonderful conversation and interesting ideas and possible solutions. Tiffany, Ian, Smitha, Andrew, and of course Mark, thank you very much for the contributions, and I look forward to being able to be on another webinar with all of you again.
Thank you.
Thank you.
Thank you.